You finally got your express entry invitation to apply your ITA. You're probably thrilled, and you should be. But before you hit that submit on the final application, we need to talk. Every single day, highly qualified people get their applications refused or entirely canceled because of the hidden traps in the express entry system. And the scariest part, most applicants don't even realize that they're making a mistake until they get the refusal letter. While the system is designed to bring in skilled workers, the way immigration officers actually evaluate your job history is incredibly strict. In this video, I'm going to walk you through the 7 most common NOC traps that destroy express entry applications. For each one, I'll show you the mistake people make, what the immigration officer is actually looking for, the real Canadian court cases that prove it, and exactly how you can audit your own application to fix the problem. Hi, if you're new to my channel, I'm Bella. I'm a regulated Canadian immigration consultant, and my job is to help aspiring immigrants like yourself develop a personalized strategy that makes your journey to Canada as simple and stress-free as possible. Let's get right into it. The biggest mistake people make is thinking their official job title is what determines their National Occupational Classification or NOC code. Applicants constantly pick a NOC because it matches their corporate title, or they try to claim a higher tier 0 or 1 category to boost their points. For example, someone called a construction manager might claim a tier 0 NOC, even if their actual day-to-day job is just loading materials and cleaning up the site. Here's the reality. Immigration officers are trained to completely ignore your job title. By law, they only care about the actual duties you performed. If your daily tasks belong to a lower skill tier category, your application will be refused. And if you claim a tier 0 job but do a tier 3 work, you could even be investigated for misrepresentation and fraud. This isn't just a policy. The federal court has ruled on this, stating officers must look at the true substance of your work, not the title. And this other case also highlights how strictly officers look at overlapping duties. So how do you fix this yourself? First, do a functional audit on yourself. Ignore your title entirely and map out your actual day-to-day tasks against the NOC database. Second, always read the exclusion section at the bottom of the NOC page to make sure your job doesn't legally belong in a different code. Finally, if you have a junior job title like administrative assistant, but you actually do complex work of an office manager, you need to write a letter of explanation pointing out that the law focuses on your duty and back it up with your performance reviews. To try and guarantee success, a lot of applicants ask their HR department to copy the NOC duties word for word from the government website and paste them into their employment letter. They think if this is what the government wants to see, I'll just give them exactly that. This is a massive red flag. Officers are specifically trained to catch plagiarism. If your letter mirrors the NOC website perfectly, the officer will mark it as fake or self-serving. Real employment letters use real corporate language and talk about specific projects. If you copy and paste, the officer will often just refuse you outright because they don't believe the letter is actually genuine. This federal court case confirms this. Officers want to see the organic reality of your job. They aren't looking for a microscopic word-for-word match. And here is how you can fix this yourself. Work with your boss to translate the NOC duties into your company's real language. Instead of saying research technical information, say something like engineer the back end using Python for our new payments system. If your HR department refuses to write a custom letter, you have to build your own evidence file. Gather your redacted employment contracts, annual reviews, and get a sworn affidavit if you can from your supervisor. I know gathering alternative evidence and drafting legal letters can feel incredibly overwhelming, especially when your HR department won't cooperate. If your reference letters aren't perfect and you don't know how to fix them, don't risk your ITA. Check my channel page to connect with us or click the link below to book a consultation. We are here to help you build a strategy to protect your application. The NOC website gives you a long list of main duties for a job. A lot of people think that if they just do one or two of those things is enough to claim the code. The law actually says you must perform a substantial number of the main duties and you must perform all the essential duties. While older court cases said the substantial technically just means more than one, the harsh reality is that officers today expect your job to match about 70 to 80% of the list. And if you don't perform the core defining task of the job, the essential duties, they will refuse you. Here's how to fix this yourself. Compare your real tasks to the NOC list. If you don't hit at least a 70% match, you need to find a different NOC code that fits you better. When you get your reference letter, make sure your employer puts the most complex defining tasks right at the very top of the list so the officer sees them immediately. If the officer pushes back, you need to write a letter citing these cases to remind them that the law doesn't require a 100% perfect match of every single minor duty. This trap catches highly educated professionals. People often claim express entry points for jobs like a civil engineer or a nurse, but they don't actually hold the official provincial or national license to practice. They think doing the physical work is enough. It is not. If a job is strictly regulated by law, doing that job without a license is considered unauthorized work. Recent IRCC updates make it clear. Any period of unauthorized work will be completely erased from your express entry points. We see this in GCMS notes all the time. Officers strip the experience away, your score drops, and your application is refused. So here's how to fix this yourself. If you work in a regulated field without a license, you have to downgrade your NOC to an unregulated technical role. For example, claim civil engineering technologist instead of full civil engineer. If you're claiming work experience from your home country, in a regulated job, you must upload a copy of your valid professional license from that country. If you worked as an apprentice under a licensed professional, your employer's letter must explicitly state that you were directly supervised, so the officer knows you weren't breaking the law. Every NOC code has an employment requirements section that tells you what education is usually required for the job. Many people don't apply because they don't have the exact degree, even if they have 10 years of experience. Worse, sometimes immigration officers actually refuse people for not having that degree. But here's the secret. Unless the job is legally regulated, those education requirements are just guidelines, not the law. The federal court has struck down officers for making this mistake. In this 2024 case, the judges ruled that officer cannot treat the phrase usually required as mandatory must-have rule. And here's how you can fix this yourself. If you don't have the usually required education, you need to proactively quote the law. Write a letter citing this particular case to remind the officer that they cannot refuse you for just lacking a degree. Then replace that missing degree with undeniable proof that you are great at your job. Provide industry certificates, proof of promotions, and letters from past managers. Arguing federal court case law with a Canadian immigration officer is not something you want to mess up. If you are missing an educational requirement and you need a bulletproof legal argument to protect your application, hire a professional. We draft these legal submissions for our clients every single day. Click the link in the description to let us handle this for you. In 2026, IRCC changed the rules for category-based selection draws, requiring a full 12 months of experience and adding new categories like physicians and researchers. People are constantly miscalculating this. Here are the strict realities. For those new physicians, researchers, and senior manager categories, the experience must be gained physically inside Canada. Foreign experience will be immediately rejected. Also, while your 12 months doesn't have to be continuous, every single hour has to be in the exact same NOC code, and it has to fall within the last 3 years. And here's how you fix this. Strictly separate your Canadian and foreign work history. If you want one of those new categories, verify your 1560 hours using only Canadian payroll data. If you are combining different jobs to reach 12 months, make sure your employer letters show the exact same NOC code. You cannot mix and match different codes. If you work part-time, create a detailed spreadsheet for the officer showing exactly how many hours you worked each week to prove you hit the required total. Finally, applicants often just upload a basic standard employment letter, assuming that if the officer wants more info, they will just ask for it. Express entry does not work like that. If your letter is missing your weekly hours or your salary, the application is legally considered incomplete. The officer won't ask for more information. They will just return your application, cancel it entirely, and you lose your ITA. And if they do send you a letter questioning your documents, called a procedural fairness letter or PFL, they are often incredibly vague. This federal court here proved that the applicants have to fight back against arbitrary cancellations. And this other case stated that officers must clearly explain their concerns. So here's how to fix this yourself. Audit your own documents meticulously against the official IRCC checklist. If a letter is missing hours or salary, make your employer fix it. If your employer won't help or went out of business, build your own proof. Submit your T4 tax slips, notices of assessments, pay stubs, and bank statements. Write a letter explaining exactly why you don't have the standard document, point to your pay stubs, and reference this particular case to assert that your application is complete and must be processed. Let's be real, the express entry system is not as simple as checking a few boxes online anymore. The era of casually matching job titles and hoping for the best is over. To get your permanent residence approved, you have to prove your exact daily duties, navigate complex court rulings, and provide undeniable evidence. You have worked entirely too hard to earn that ITA to let a hidden knock trap ruin your Canadian dream. These are high-level complex legal issues. If you want the absolute peace of mind that your application is flawless, do not leave it to chance. Check my channel page to connect with us, or click the link below to book a consultation. Let us represent you, fix these traps, and prepare your application the right way the first time. Please like this video if it helped you spot a mistake, and subscribe for more honest, actionable Canadian immigration advice. Thanks for watching.